Into the transcripts of July 17, 2012, right after Rikki gave her kidnapping interview with Detective Dan Whitten. The court. Alright, let's go on the record in the matter of People versus Rikki Johnson. Token. David Token on behalf of the people. O'Malley. Stewart O'Malley for Miss Johnson, who is present and out of custody. Court. Alright, the first thing the court has before me is a felony complaint alleging the count accessory after the fact on November 23, 2011. Counsel, have you received a copy of that complaint? O'Malley. Yes, Your Honor. Court. Waive formal reading and advisement of rights. O'Malley. I do. The court. And the court does have a plea agreement in front of it. Miss Johnson, in order to enter your plea, I have to ask you questions. The one thing I do ask is the young lady sitting down in front of us is taking down everything, so if you can speak loud enough for her to hear and understand you, I'd appreciate it, okay? Defendant. Okay. Court. All right, ma'am. Is your true name Rikki Lee Johnson? Defendant. Yes. Court. And is your date of birth January 4th, 1992? Defendant. July 4th, 1992. The court. Ma'am, I'm showing you a 3-page document entitled Declaration by Defendant under Penal Code Section 859A. Do you recognize this form? Defendant. Yes. Court. Under here, indicating it has a signature above that line. Is that your signature? Defendant. Yes. Are those your initials in the box? Yes. Before you initiated and signed this document, did you go over both the printed and handwritten sections with your attorney? Yes. Did you feel like you understood everything on this form? Yes. Did you feel like you understood your constitutional rights as set forth in this form? Yes. And did you feel like you understood the penalties, punishments, and consequences of entering a plea as set forth on this form? Yes. In order to enter a plea, you have to waive and give up certain constitutional rights. You do have a right to a preliminary hearing and then a right to a trial by a jury, at which you have an attorney that would either be appointed for you if you could not afford one, or you can pick one of your own if you decide to pay for that attorney. Through that attorney will be able to confront and cross-examine witnesses against you, present evidence, and subpoena witnesses on your behalf. You also have a right to testify on your own behalf or remain silent. Do you waive and give up those rights so that you could enter your plea today? Yes. My understanding of the agreement in your case is that you're going to be pleading guilty to violation of Penal Code Section 32, that's accessory after the fact. That's punishable of up to 1 year in county jail, 16 months, 2 to 3 years in state prison, and you're doing that because you agreed with the district attorney you'll be placed on felony probation for 3 years with credit for time served. I'm going to go ahead and sentence you today. Is that your understanding of this agreement? Yes. Did anybody promise you anything other than what's on this form in order to get you to plead today? No. Did anybody use any threats or violence against you to force you to change your plea today? No. Are you under the influence of any alcohol, drug, narcotic, or prescription medication that interferes with your ability to understand what's happening today? No. Do you feel you've had enough time to discuss your case with your attorney? Yes. Do you have any questions for me? Yes. Okay, go ahead. Can I request an out-of-state for probation? Well, to do an out-of-state probation, that's something you have to work out with the probation department. The court doesn't do that. Okay, thank you. Any other questions? No. You understand that the court is going to grant you probation. I'm going to give you the terms and conditions of probation that are not set forth in the plea agreement, but are set forth in a separate document entitled Felony Terms and Condition of Probations. The defendant. No audible response. The court. You have to answer out loud for me. Okay. Do you understand if you're not a citizen of the United States, the consequences of deportation, exclusion from admission into the United States, or denial of naturalization pursuant to the laws of the state? Defendant. Okay. Counsel, do you agree you've had adequate time to discuss all these issues with your client as you went over the plea form? Yes. Are you satisfied that she understands everything on the form? Yes. Do you join in the waivers? I do. After directly examining the defendant, the court will find that the defendant has read and understood the plea form, that the defendant understands the nature of the charge to which she's pleading, all consequences and punishments to which she's pleading, and each of her constitutional rights, that the defendant knowingly, intelligently, freely, and voluntarily waives each of her constitutional rights. The court will allow the defendant to withdraw her previous plea of not guilty. Ms. Johnson, in case number FSB 1203107, charging you with a violation of Penal Code Section 32, accessory after the fact. How do you plead? Guilty. Counsel, join. Mallory, join. counsel be willing to stipulate that if the court were to review the police report in this matter, it will find a factual basis for the plea. So stipulated. O'Mallory, so stipulated. The court will accept this stipulation. The court will further find that the defendant has personally and orally entered her plea in open court, that the plea was entered freely, voluntarily, knowingly, and intelligently by the defendant, that there is a factual basis for the plea, and the court accepts the plea. Now, Ms. Johnson, you do have the right to have your sentencing delayed for up to 20 court days, and also for the court to refer the matter to probation for report and recommendation. Do you waive and give up the right to delay on a probation report so I could go ahead and sentence you today? Defendant, yes. Court, waive arraignment for judgment and sentence. O'Mallory, so waived. Court, any legal cause? O'Mallory, no, Your Honor. Court, all right. Court makes the following findings: that a motor vehicle, Mr. Token, no, Your Honor. The court, not involved in the commission of the offense. Court will order the Sheriff's Department to collect a sample pursuit on Penal Code 296. Court will order a $70 CSC fee. Court will order a supervision fee of $26 per month now. Court will order probation revocation restitution fine in the amount of $240 that will be stayed pending successful completion of probation, imposed if there is a revocation of probation. Court will find the defendant does not have the ability to pay for court-appointed counsel fees. Court will impose a victim restitution fine in the amount of $240. Any fines and fees payable at the rate of $40 per month. The first payment to begin 30 days from today, and the court will withhold pronouncement of judgment for the offense of accessory after the fact of violation of Penal Code Section 32, and place the defendant on supervised probation for a period of 36 months with the following terms and conditions. Term number 1. Serve 1 day in San Bernardino County Jail with credit for time served in a matter of 1 day. Term number 2 is violate no laws. Waive reading of all other terms, conditions in open court. O'Mallory, I do, Your Honor. Okay, I'm showing you a form, felony terms and condition of probation. Did you have an opportunity to review that with your attorney? Yes. Do you feel you understood all those terms in there? Yes. And are you willing to accept the terms set forth on there? Yes. And did you sign the form at the bottom? Yes. All right. The court will order the terms and conditions set forth on the felony terms and condition of the probation form as modified. I will order you to report to probation. Check in with them when you leave here today. Okay? Okay. Were there any booking fees in this case? To Yucaipa Sheriff, Your Honor? Well, sheriffs, okay, no booking fees, all right. Token, Your Honor, is there any way that we can approach? Yes, off the record. The court, well, I think if you go over there and explain who you are, that should be fine. If not, just bring her back here and I'll give her another day to report. Token, thank you. O'Mallory, thanks, Your Honor. Proceedings concluded. First of all, they convicted her of a crime committed on November 23rd, 2011. There was nothing in this case committed on November 23rd, 2011, so I feel Rikki Johnson was never charged in this case. This case was committed, or this crime was committed on September 28th, 2011, and on November 23rd, 2011, Rikki Johnson was detained with Joe Johnson when Joe Johnson was arrested. I feel that Rikki Johnson was not charged in this case. Thank you.